Chapter 7 Recourse against Arbitral Award Section 34 An application for setting aside arbitral award is filed under Section 34 of Arbitration and Conciliation Act. The provision for setting aside the arbitral award is laid down under Section 34. A defendant enter appearance in money suit and file a petition informing the court that there exists an arbitral agreement between the party. However, during the pendency of such adjudication by the court, the defendant get an arbitral tribunal constituted as per stipulation of the agreement and obtain an award in his favor. The award will be a valid award. Who is competent to stay the execution of arbitral award? The court before whom the application is made under Section 34 of Arbitration and Conciliation Act 1996. Which one of the following is not a ground for setting aside the arbitral award under Section 34 Arbitration and Conciliation Act? None of these. Party to the arbitration agreement are resident of the Lucknow and Calcutta. The contract was performed at Banaras. The parties agreed to the arbitration proceeding will be conducted at New Delhi, were held at New Delhi, where will be the petition for Section 34 of Arbitration Act 1996 is filed. Delhi. An arbitration award pursuant to an arbitration agreement dated 1st November 2015 can be set aside under Section 34 Arbitration and Conciliation Act. On the very filing of petition under Section 34 of Arbitration and Conciliation Act 1996 for setting aside of an arbitral award in arbitral proceeding, which has been commenced after 23/10/2015, arbitral award remain executable unless execution thereof is stayed by the court before which such petition is filed. An arbitration award under Arbitration and Conciliation Act 1996 means has the status of a decree only after time of 3 months for making an application to set aside the same has expired and such application have been made has been refused. An application to set aside an arbitral award under Arbitration and Conciliation Act 1996 may be made within a time period of the following number of day that has elapsed from date on which the party making application has received the arbitration award. 3 months. A petition under Section 34 of Arbitration and Conciliation Act is filed on the 41st day after the expiry of limitation prescribed in Section 34C of the Act, along with the application condoning the delay. The court must dismiss the application for condonation of delay, as well as petition under Section 34 of Arbitration and Conciliation Act 1996 on ground of limitation. The petitioner in the petition under Section 34 of Arbitration and Conciliation Act so that the another method calculating damage was preferable than one adopted by the arbitrator, then the court must dismiss the petition. In which case Supreme Court held that under Section 34 of Arbitration and Conciliation Act, court examining the validity of the award. Oil Natural Gas Corporation versus Shaw Pipeline 2003. An arbitral award may be set aside by the court if it is in conflict with the public policy of India, a party under some incapacity. Under the Arbitration and Conciliation Act, an application for setting aside the arbitral award must be made by the party after receiving the award within 3 months.